Good morning, everyone. Welcome to the Alliant webcast series, and thank you for taking the time to join us today. Today, we will discuss New York labor law and the impact of COVID-19. I am Katia Lati, and with me are my colleagues, Kathy McGrath and Diane DeLuca. This informative webcast is presented by Daryl Whiteley and Ken Walton, managing partners at Lewis Brisbois in New York and Boston. We will have a 45-minute presentation followed by a 15-minute Q&A. Please use the Q&A section at the bottom right corner of your WebEx window. And with that, I will hand over the presentation to Daryl Whiteley.
Thank you very much, Katya. Just to add, we will be presenting some aspects of Massachusetts law to today's presentation, and also Billy Kim, who's a junior partner at Lewis Brisbois, will also be joining us for this presentation. So Alliant had asked us to put this together really because it's a timely presentation for anyone in the construction industry. As we all know, the construction industry is ramping back up based upon the closures that occurred according to the COVID-19 pandemic. So they've asked us to put together this as a sort of a guide or a resource for all of you in the construction industry to understand what to do on a precautionary basis, as a preparation basis, to best defend against exposures to COVID-19 for all of your workers, and also to talk about some of the litigation concerns that exist based upon this new environment and how we can best deal with that. As we know, the COVID-19, everything we've read, it's the most difficult part of it is it's got an unprecedented ease of infection. It's just really contagious, far more than almost anything that we've ever come across. Specifically, it can survive on steel and on plastic, which is very important in the construction industry, for up to 3 days. So one could just envision what a difficult situation this is for construction. It can also survive in the air for as much as 14 minutes. So just during normal talking, it can float out there in the air. So this is not business as usual. We have to take extraordinary precautions to deal with this. And if you can look at this, knowing the mortality rate of COVID-19 as similar to all of the things that we've done in construction over the last 15 years to reduce construction fatalities, this is potentially another type of construction fatality. It really has to be looked at that seriously.
This is Ken Walton, and I'm the managing partner in the Boston office. And as Daryl will be discussing issues regarding New York law, I will be touching on some of the issues in Massachusetts, and we'll also overlap in certain areas when we talk about OSHA, for example. As you all know, in an attempt to stunt the spread of COVID-19, millions of Americans have been asked to do really the unthinkable. Don't go to work, don't go to school, don't leave your house. And these are unprecedented events in all of our lifetimes.
Hi, this is Billy Kim from Lewis Brisbois in the New York office. At the start of New York's pause order in mid-March, there was some confusion as to what construction projects were allowed to continue. Construction sites were initially exempt from the pause order. There was some backlash from the public regarding the necessity of these projects. The governor's office thereafter clarified that only essential construction was allowed to continue during the pause. This included construction involving medical facilities, infrastructure such as roads, bridges, transit systems, affordable housing, etc. However, as the various regions of New York continue to meet the metrics for reopening its non-essential businesses, these restrictions are slowly being lifted. It should also be noted in Massachusetts, construction sites have been up and running since May 18th, with distancing and safety measures in place in order to deter the spread of COVID-19. In order to lift the pause order, New York State has created a list of 7 different metrics that need to be met, such as decline in hospitalizations, decline in deaths, availability of hospital beds, and diagnostic testing and tracing capabilities. As of May 26th, every region in New York except New York City have met the requirements in order to enter phase 1 of reopening. This phase 1, as I mentioned before, also includes construction. The chart here was presented by the governor's office on May 26 and indicates that New York City had met 5 of the 7 metrics. However, it should be noted the following day, May 27th, New York City's share of ICU beds actually went down below its 30% threshold. And New York City now, as of May 27th, only meets 4 of the 7 requirements in order to enter phase 1. So it is a fluctuating standard.
So to sum up, New York is open for business construction-wise everywhere, including Long Island, on New York, except for New York City. And it looks like New York City's on pace to open probably in June with just one more metric to go. So this is really important on a preventative basis and on a planning basis to understand what you're going to need to do to reopen. As Billy mentioned, for the essential construction services, they were all important infrastructure projects, hospital projects, homeless shelters, protection of health and safety. Also, single workers were allowed to work in construction all throughout. And basically, this was a major shutdown of New York. As much as 90% of construction in New York City was shut down. Next chart will show you really, even with 90% shut down, how many construction sites were ongoing even during the height of the pandemic. So now that they're coming back, you'll have even more cautions that we need to take. Reopening of New York construction, Billy, if you want to handle that.
As discussed, New York has outlined a plan to reopen New York State during this pandemic. And as we mentioned, phase 1 includes construction. There are 4 distinct phases, though, to reopening the businesses. There's the reopening of construction, agriculture, manufacturing, and wholesale industries, as well as some limited curbside retail. And phases 2 through 4 include the reopening of restaurant and food services, arts and entertainment, such as movie theaters and Broadway, and finally, education systems. But again, phase 1 is the one we're concerned with, which includes the construction industry.
So in the reopening of New York, and even during the time when all of it, most of it was closed down, the DOB was doing a great deal of inspections to monitor any active construction site. And they were checking for the obvious things, including social distancing and the wearing of PPE, such as masks. And they were doing that on an extraordinary level all throughout New York City. The good news is a lot of the DOB inspections turned up that the construction workers were not only wearing their masks during construction, but also out on their break. So I think the construction workers obviously get the seriousness of this and are doing everything they can to comply. A lot of companies were also looking, as they were planning to reopen, to extend the working time to 24-hour construction, which would allow much more significant spreading out of the workers. And this was deemed as a very positive part of the planning process.
This is an unprecedented time for the entire country, so there's obviously cautionary examples that have already taken place of what happens if we get it wrong. For example, in May of 2020, more than 230 workers on a construction project at a nuclear power facility in Georgia were tested positive for COVID-19. Meatpacking plants across the country are turning into hot zones of internal infection. 10 workers at a Boston construction site tested positive for COVID-19 after working without masks. These will not be the last examples, and we all know that if workers are infected on the site, they can then go home and infect others.
Yeah, in New York, already on 2 of our clients' work sites, we know of workers' compensation claims that have been filed against employers citing exposure to COVID-19. And we have every expectation that the plaintiffs' bar in New York will look to institute general liability claims under common law and under New York labor law. And it's in particular when there are clusters of infections that develop around a particular construction site. And we'll get into the details of why that is. And in Massachusetts, we're also going to see, we believe, common law negligence claims as the primary litigation theory regarding COVID-19.
Other potential claims arising out of COVID-19 are personal injury claims involving employees or visitors at the site who may bring claims against a general contractor or an owner as a result of losses arising from being infected by COVID-19 while at the site. As Daryl mentioned, they're more likely than not claims of negligence that will require a plaintiff to prove that the owner, general contractor, had notice, actual or constructive of the hazardous condition. An example would be a visitor to the site who claims the general contractor or the owner negligently failed to protect him from being infected after allowing him on site despite a prior cluster of infections of personnel at the site and did not advise of such potential risk. This would not apply to the claimant's employer, obviously, due to the workers' compensation bar.
And I'll just add before the next slide that it might seem logical to everyone, for anyone who's running a construction site, to say, how can someone ever possibly prove that they were infected on a construction site when it's well known that New York City in particular is a hotbed all across the city. Boston, unfortunately, similarly pretty well infected. So how does an employee prove that it occurred on the workforce? And the answer is he doesn't really need to. All he needs to do is prove notice, because no one's ever going to prove exactly where an infection came from. All the worker would have to prove is that the owner of the construction site or the general contractor or construction manager had notice, had reason to believe that infections were occurring. As I said, this is really to serve as a guide or a resource for you. And what we've done throughout this presentation, created links for many of the public proclamations or public guidelines that have been asserted through the course of this pandemic for the construction industry, especially those from New York State, from the governor's office, from the Department of Buildings, from OSHA, from the Association of General Contractors, which is an outstanding organization that has really been putting out some great literature on the topic. So these are the 5 basic sources of information that we're relying on or trying to transmit to you guys in this presentation. Ken, if you could maybe address the first one.
Sure. And so as Billy mentioned, Massachusetts, which was one of the states hit hardest by COVID, not as hard as New York, which is obviously at the top of the list, but in the top 5 nationwide with regard to cases and deaths. Massachusetts reopened for construction on May 18th, and they did issue a set of guidelines for what needs to occur on construction sites. For example, Massachusetts has instituted mandatory guidelines, including 0 tolerance for sick employees. Any employee who feels sick must go home. Any employee observed as sick on the job must be sent home. There's also a self-certification requirement. Prior to starting a shift, all employees must certify to their supervisor that they have had no signs of fever or temperature above 100.3 degrees, coughing, breathing within the last 24 hours, and have not had close contact with an individual diagnosed with COVID-19. Employees who do not self-certify or show symptoms must be directed to leave the job site. In addition, there's work site prevention, a 100% glove policy, wash stations, eye protection, social distancing when possible. And we all know that in construction sites, there are activities where workers need to stand together in order to complete a heavy construction task. But to the extent possible, social distancing needs to be followed. There's no handshaking. Hands, again, must be washed. No congregation policy, so you can't have job site meetings with 100 people standing around. Avoid face-to-face meetings. And at each job briefing toolbox talk, employees are to be asked if they're experiencing any symptoms. And then there's also a listing of all the things that need to be cleaned: the restrooms, the surfaces, equipment, machines. Finally, there's workers returning to work. All workers who are considered close contacts to COVID-19 should not return for 14 days. All workers who leave during the day and develop COVID-19 symptoms shall not return to the work site until they're released by an official healthcare provider. Finally, identification and isolation of infectious individuals. Upon learning of an infection, the contractor must immediately notify the designated safety officer, and the contractor then must take immediate steps to sanitize common areas, and that worker should be isolated from the other workers until the sanitation process has been completed. So these are going to be completely different work sites with a whole new set of regulations that must be followed pursuant to these instructions.
And similarly, in New York State, on May 13th, 2020, the New York State Department of Health issued its interim guidance for construction activities. And New York is calling everything interim, and as you may have noted, they're calling that because this is changing so quickly. you have to check back with this all the time because these things are moving. And right now, New York and New Jersey are doing a tremendous job with testing and also with the beginning of tracing. So I'm sure that those kinds of items are going to be coming in as mandatory parts of the guidance in the next few weeks. So check regularly with these updates. New York, as I said, has issued these recommendations. They're pretty similar to Massachusetts. A few differences: 1 worker per 250 square feet is the recommendation. Face coverings are mandatory. 6-foot distancing is mandatory. The hoist, they've recommended 1 worker at a time. That seems pretty impossible. In another section, they've indicated 50% use of the hoist if people are properly masked. They're a little bit different than Massachusetts, but the guideline is you want to, on every element of these issues, you want to err on the side of caution. We just can't get this wrong. It's going to set the construction industry back. It's going to be dangerous for the public. And we have to be overly precautious here, just like we are with fall protection and so forth. Face coverings, we talked about cleaning of objects. In practical terms, we want to really reduce the sharing of tools. That should be very limited. Everyone should be able to use their own tools if possible. If you do have to share them, obviously they have to be clean between shifts. The obvious things that come to mind are food. It's not mandatory, but workers should be encouraged to bring their own food from home. That cuts down risks to local restaurants, cuts down risks of people having to eat anybody else's food. It's your own food that you're bringing from your home. Workstations have to be modified. OSHA requires it. We got to have water, running water, and soap that the workers can all go to and wash their hands for 20 seconds. An outhouse by itself just isn't going to do. You have to have some way for workers to wash their hands with soap, and OSHA requires that that be warm water available. The screening is mandatory for all sick employees. All employees should stay home, obviously, if they're sick. They have to be trained on that. Health screening has to be done. It's ideal if that screening is done remote from the site. Encourage your workers to take their temperatures before they come to work. Obviously, their temperature has to be taken before they're let into the site, but then the worker is already there. A lot of this can be done, even though employees for construction sites are used to gathering in toolbox meetings and so forth. Some of this can be done remotely. Some of this can be done over Zoom. Like in most industries, we can encourage that in terms of training. Also, Zoom, if it's used, allows you to record the meeting so that you can not only show that you've trained your workers over a remote technology, but also that there's a recording of that and it shows that they were there to hear what you told them, which is important when the litigation begins. So remote training, nothing is required there, but that's something that we're just recommending as an abundance of caution. If you can reduce the size of groups, if you do have to gather together, and obviously spread out, and obviously wear masks when you're even just speaking to one another. Another very important thing is to have proper signage posted all around the construction site, which helps to train the workers on what they need to do, i.e. washing their hands and so forth. New York State is mandating that with regard to a reopening of a construction site that they have a reopening safety plan. And the template for that is also available to you just online under the New York State Department of Health website. It's mandatory that you have a reopening safety plan. It's not mandatory that you send it in. It's not mandatory that it be approved before you start, but it does have to be on site and available if you get inspected, and you probably will get inspected because, again, New York City is taking all of this very seriously. Enforce and document. This is really important not only for safety, but also now for litigation focus. Obviously, all the safety things we're doing is for safety. It's to keep your workers safe. That's the best prevention of any lawsuit. But if people do get sick, you're going to want to be able to defend yourself in a lawsuit from a person who sues. So it's critical that all of the things that you're doing, all of the compliance that you're engineering here and putting forth, all of that has to be documented, that you are enforcing all of the rules from those different segments of the government that have set out these rules, that you're enforcing all of those rules and that you can prove that you've enforced those rules. So how do you do that? You have to document that instructions have been given and explained, and critically that they've been received by the workers. So the best way for that, just like we do before COVID, is you need to get sign-offs from those workers. In litigation, the best thing we have is documents that are signed by people that have injuries, because those documents prove, they go right into evidence, and they prove that a person received a certain amount of instruction, that they acknowledged that they should have been doing the work a certain way. Here, you need sign-offs to prove that these workers were warned about social distancing, that they were given every precaution, that you can prove that later on in a court of law. There really has to be almost a zero tolerance policy here for noncompliance, and New York is obviously recommending that people be sent home if they're not complying in any way with the rules. And if you can document that you are sending people home who have not complied, that's going to work in your favor down the road if there is a litigation.
In addition to the state-specific guidelines that we've been talking about from two of the hardest hit states, there's also the federal overlay of OSHA, which applies throughout the country. Currently, OSHA has not implemented specific guidelines for the construction industry. However, there are existing OSHA standards that apply to all workers for COVID-19 type hazards. Enforcement is discretionary, but employers' good faith efforts are important, and we've provided a few links for you to take a look at. If you get into the guidelines, these are some of the things that they say that you can see the overlay and to some extent the duplication with the state guidelines. Construction managers and owners need to develop an infectious disease and response plan based on federal, state, local health agencies. They have to be willing to implement basic infectious prevention measures, i.e. the hand washing, the respiratory etiquette, and all the other things we've been talking about, like social distancing on the construction site. They need to develop procedures for prompt identification and isolation of sick people, develop and implement and communicate about workplace flexibilities and protections, implement workplace controls and engineering controls, administrative controls, and also to provide personal protective equipment, masks, based on the hazard to the worker. Now, as I mentioned, these are mere guidelines. However, we can all foresee a case where a plaintiff's attorney looks at the guidelines and then accuses a construction manager or an owner of not complying with them, and that non-compliance leading to a case of COVID-19 that could have been prevented. So the OSHA guidelines are important, and they need to be reviewed.
For those of you in New York City DOB has also put out very clear regulations and guidelines for the construction industry to reduce the risk of transmission. Also, the New York City DOB is one of the enforcing agencies. They will be looking for the permit holders on the job site, and the permit holders are the ones that are going to be responsible for enforcing the physical distancing, mask wearing, and so forth. They're going to look to the permit holder and hold that permit holder accountable. There's fines up to $10,000 that can be issued first-time offenses. I don't know how strictly that those fines are being applied, but they're certainly out there. That's a big number. They're going to have that power. That's different, mind you, and we're going to get into the New York labor law, even though the permit holder is responsible for enforcing these safety regulations. Under the New York labor law, the owner, construction manager, any trade in the chain of work where the worker was injured could be strictly liable for personal injury. DOB guidelines, I'm not going to repeat them. They're pretty common to the ones we've already talked about. I will say they do talk a great deal about investigation, which makes a lot of sense. Kind of comes into the tracing era that we're entering into as a society. So they are encouraging, just like one would investigate how an accident occurred, they are encouraging an investigation of how someone got COVID or who got COVID and what happened once that was known, and obviously proving that that person was sent home. It has to be documented, and it has to be reported if someone has a known case of COVID-19 on the work site. As I said, the AGC has put together a great deal of really helpful information. I encourage you to join that organization. and follow a lot of their guidelines. They have presentations like this, and they also offer a lot of material like signs that you can post. And they're just a very good organization for keeping track of all the regulations that are coming out on this on an ongoing basis. Testing used to be obviously a real problem. Everyone said there was testing. There didn't seem to be any testing available to anybody anywhere. That's changed. And now, at least in New York State, you have the ability, if you want to get a test, to get a test. The New York State has authorized 28 public and private labs to test. People are testing all over. And also private organizations, CityMD, for instance, offering both the tests for COVID-19 and also the antibody test to demonstrate that you've had it. There's some questions about the reliability of the antibody test still. I think that's developing. Johns Hopkins is offering some very good information on that. We'll try to get you some follow-up. It isn't required that you have every worker get tested before you show up, but why wouldn't you want to do that? You could rule someone out. The other great danger of this disease is that as much as 80% of the workers or the public that has it doesn't know they have it because they have no symptoms, and yet they can be a vector of transmission. So though it isn't required, why wouldn't you want to insist that all of your workers be tested and not show up if they have COVID-19? It seems very basic to me. Massachusetts can also testing widely available.
It is, Daryl. The governor's made a big deal about the number of testing sites, and we provide a link in the materials that shows you all the different areas in Massachusetts where you can get tested. Another important area is signage. Signage is important because it sends a message. It sends a message to people on the site and even people driving by the site that the participants are taking all of these new rules and regulations seriously. And signs as simple as everyone must wear a mask and proper social distancing. It sends a message to even an inspector who might be driving by that the contractors are doing their best to follow the applicable regulations. We provided you with some sites where you can get these signs if you want to purchase them. They're relatively inexpensive, and there's a number of different signs that cover all of the areas that we're talking about today.
So New York State, as many of you know, has a special law, New York labor law, which imposes strict liability on owners, general contractors, and any contractor that's in the trade of work where the worker was injured. And it imposes strict liability regardless of actual negligence. So just because of who you are and whether something happened on your work site, you can have liability. Now, fortunately, we don't really anticipate that Labor Law 240 is going to be implicated much under COVID-19. It's conceivable that in social distancing, one might have a situation where someone's on a ladder and the ladder isn't being held, and someone may use that as an excuse. You might see a Labor Law 240 case or two like that down the road, but I don't think that's a major concern. 241.6, which is sort of the mama bear of the New York labor law, is another strict liability provision which does not require the fall from a height, does not require something fall from a height or a person fall from a height. It's premised upon what's called the New York State Industrial Code rules. And we'll talk about those rules as a predicate to 241.6 liability. Also, New York labor law has codified common law negligence as Labor Law 200, and we're going to be talking a lot about that as well. So Labor Law 241.6 is a concern because what it says is an owner, a GC, or any trade contractor in the chain can be strictly liable if one of these provisions of the Industrial Code rules were violated, any one of them. So what we did is we went through the Industrial Code rules and tried to identify those rules that seemed most likely for plaintiffs' attorneys to pick at to try to prove that something was done wrong, that there was some violation, therefore enable them to trigger strict liability against the owner or the GC of a construction project. And what we've done is list those out. And I think we have good defenses to all of them. But I just want everyone to be aware of what they are. 23-1.8 B1 talks about personal protective equipment, specifically masks. You know, with all that we know and everybody wearing masks all around the country, this would seem to be the most easy target for a plaintiff's attorney. Fortunately, it doesn't talk about the requirement of using one of these masks with regard to the transmission of viruses. So there's no indication in the industrial code rules that you need to have one of these masks for the obvious purpose of preventing COVID infection. Instead, as you know, they're for flame cutting operations, painting, hazardous materials, hazardous chemicals, but nothing about virus transmission. So we do think, even though the plaintiffs will use these and will sue under these, we do believe they are defensible. But still, you want to have your workers wearing masks. 23.1.7G, air contamination or oxygen deficient work areas, another area which seems close, concerns us, but this industrial code deals primarily with confined space. And so in the general construction site, which is pretty wide open, where these codes do not apply, so you don't have to worry about them. And we would really suggest that in a confined space, and social distancing is a major focus of the workplace rules, that kind of work be really restricted to one worker at a time. We don't want to tempt a violation of these industrial code rules, so really reduce that if you can, so you never have 2, 3, 4 people in a closed area. That's only going to heighten possibility for liability under this section. Again, we think it's mostly defensible with regard to the wide open remainder of the construction site. And next, 23-1.9 is a industrial code that deals with drinking water and sanitation. It requires washing facilities with warm water, soap, and individual towels be provided for all employees. I don't know how realistic that is, but that is what the code requires. And now under this environment, one would think that such a precaution would be very well advised. We do believe that even though plaintiffs may sue under these sections, that they are defensible, again, because the rules just did not contemplate the virus as the reason. Instead, it's for corrosive substances, chemicals, other harmful substances. That's why access to water, warm water, and soap are required. So again, we think it's defensible, but we can't stop a plaintiff from suing under that provision. So industrial code rules, all presumably defensible, but possibly they're going to be a focus of attorneys on the plaintiff's bar. So understand those three and take extra precaution to train your workers and provide them with whatever they need so that those violations can never occur. Now, Labor Law 200 is, again, more of a codified common law standard of care, things that we all pretty much understand in the construction industry. When you have either you create a problem or you have notice of some problem, that can result in a finding of negligence. If you knew of a problem and ignored it, that can result in a finding of negligence. So what Labor Law 200 has two ways of going about proving liability. One is that basically it requires an owner and a general contractor to use reasonable and adequate protection. The owner can usually get summary judgment on a 200 claim because usually the owner and frankly the GC don't get into the weeds of controlling the specific means or methods of a project. So that's one way to defend those cases. But with regard to COVID-19, the theory the plaintiffs are likely going to use is that someone, maybe the permit holder, maybe the employer, maybe the general contractor, had notice of some unsafe condition. We all know that this COVID virus is spreading around. We all know it's out there, but what is notice of a specific condition? I think it has to transfer to notice on that construction site. And when do you have that notice? You probably don't if you just have one case and you take immediate precaution. You send the person home, you do contact tracing, you find out all the people that that person was in touch with, and you send them home or get them tested. If you take precautions on one event, I can't think that anybody could say you had notice of a problem when you did everything you could once you found out there was a problem. The danger comes when you don't do that. When you know that someone on your job site is tested positive and has the potential to spread, and you don't send that person home, don't do investigation, don't follow up and protect all the people around them. If you get to a situation where you have a cluster or you have a widespread contamination of 2, 3, 4, 5 people all in a certain area, then you know you have notice. And you know at that point it's already too late to really effectively be able to defend a lawsuit that says you shouldn't have allowed this person to come to work in this area. So that's where the danger comes. It comes from multiple or from clear evidence that it's more than just one. Those are going to be the cases that are going to be very hard to defend. So again, we can't stop plaintiffs from suing under the New York labor law. They will sue under 241.6. Most of them are going to be defensible. They will sue under labor law 200, and they will be able to prove their cases, in my view, more easily if there is some pattern that appears. So as soon as something happens, you have to ramp up whatever precautions you have in your plan, and you have to execute that, and you have to document that. And that might mean shutting down a work site, or it might mean shutting down an area of a work site or a particular trade. But you have to err on the side of caution.
We want to touch on just a few business considerations that we're looking down the road, seeing what may develop arising out of claims that come from the AIA documents, among other situations. Owners, contractors, subcontractors must prioritize the health and safety of their employees, especially during this time period. OSHA, interestingly, has issued COVID-19 guidance classifying workers into 4 basic exposure risk levels. Most workers fall into the medium level, and that's where they have placed construction workers. Obviously, the very high category would be doctors and nurses dealing with COVID patients. But personal injury claims can stem from a failure of owners or contractors to have a safe site for their workers. In addition, owners and contractors remain liable for costs incurred for work already performed, and affected contractors and subcontractors must take the steps necessary to seek repayment for that work. Currently, there's a cooperative process, I would say, in the construction industry. Everybody's just trying to get going again and trying to get in place proper safety procedures for their workers. But at some point, the rubber is going to hit the road, and people are going to realize the costs that have been lost due to this shutdown, and the claims will come. The interesting part of the common law claims that we will see for breach of contract and negligence is the issues that the parties will be fighting about have never been litigated during the past 100 years, and certainly not since many of the AIA documents went into effect. So owners and contractors need to seek appropriate extensions of their completion dates to avoid contract-based claims. In addition, another clause that's contained in most contracts is the force majeure clause, which generally excuses a party's performance of its contractual obligations that were beyond the party's control. An example is in New York, to an act of government that has halted all non-essential construction work. If your project is shut down as a result of the act of government, it should be considered an event of force majeure. This particular issue of whether COVID-19 or other deadly disease has never, to my knowledge, and I've done some research on it, been litigated in the context of force majeure. So I think this will be something that we'll see. Courts are going to have to interpret that and decide whether this is, it seems to me it's obvious that it should be in that category, but I think different courts are going to say different things about it. Other contract claims. Obviously, a contractor may bring a claim against the owner for delays in additional general conditions. That's probably not going to be looked at too happily by a court during this time period, but an owner may bring a claim against a contractor for failing to timely finish a project or walking off the project. Unfortunately, some companies may not survive COVID-19, and those are issues where the pieces are going to have to be picked up on a project if a contractor is no longer in business. Finally, termination by a contractor. If a contractor determines stopping its work on a halted project is in its best interest, There are provisions in the AIA documents A201, 217 that allows the contractor to terminate the contract if the work is stopped for 30 consecutive days due to no fault of the contractor. So again, that's an issue that will likely be litigated, because can a contractor be blamed for having stopped work for 30 days? Of course not. In fact, most states have issued orders saying that not only should they stop work, they have to stop work. And a global review of all of your contractual provisions about force majeure, termination, or suspension, and whether those provisions have been included. For example, if you have those standard provisions in an owner general contractor agreement, it's important that they also be included in the general contractor subcontractor agreement, because if they're not uniform, then that could lead to issues of conflicts that will have to be resolved by the courts. The doctrine of impracticability of performance, another common law defense, I fully expect that it's going to be tested. It basically says that a party must show that as a result of an unforeseen event beyond the party's control, performance was impossible or impracticable from a commercial perspective. And frankly, it's rarely been successful as a affirmative defense in case law. I've given you a case site here. This is an extraordinary circumstance. So it may be time to use that defense, that legal common law defense, in appropriate circumstances when COVID-19 has just created circumstances that make completion of the project wholly impractical or impossible for a variety of reasons.
So thank you all. Just to sum up, this is a very uncertain time, and I don't think anybody has all the answers here. It is a lot of feel things out as it goes. But we're recommending that because of all the liability issues and safety issues that could result from COVID-19, that contractors heed all of the safety guidelines and err on the side of caution in following those to the letter, if possible, because that's going to be the best way to reduce the transmission, first off. Secondly, it'll mitigate your liability if there are claims, either under general liability or New York labor law, and it certainly strengthens your defenses to common law negligence claims if you've done everything that every governmental agency has asked you to do. You can't do much more than that. So to me, that's the guide that you need to come away with here. It's follow these guidelines very seriously, because there are serious health and safety and litigation consequences. We have a general question and discussion period, but if you want either the email version of this presentation, which contains the hyperlinks, just email either Kevin or myself or Billy. And if you want a hard copy, we can also send that to you. Just make sure we have your address. Thank you for all attending. We have questions and answers now.